At any given time, 5,000 Vermonters are living with a diagnosis of a terminal illness, and they are making choices about their end-of-life care and plans. These are the faces of some of the people who have chosen medical aid in dying over the past 8 years since Vermont's Act 39 was adopted. They and their families frequently write with deep gratitude for the peace this option has provided. Every person qualifying for aid in dying must be diagnosed by 2 doctors as having a terminal illness with 6 months or less to live, and they must be capable of making their own medical decisions. When Act 39 was finalized in 2013, legislators placed great weight on preventing improper use of the law, so the process includes 5 qualification requirements, an 8-step procedure, and full documentation. Participation in the law is completely voluntary. Vermont is among 11 states that have similar laws, providing end-of-life choice to 22% of Americans today. Now, with 8 years of experience and 0 reports of abuse, it is time to make proper use of the law less onerous for dying people. Senate Bill 74 was introduced in February 2021 to make 3 important adjustments to the law. First, it would remove the requirement that requests for aid in dying be in the, quote, physical presence, end quote, of the doctor. Doctors would then follow existing law and practice on the use of telemedicine in deciding whether they can make the required determinations under Act 39 remotely or whether they need to see the patient in person. Note that Vermont is the only state in which requests for aid in dying have to be made in the physical presence of the doctor. Please listen to Karen Olschlager, who was 37 and dying from stomach cancer, when she needed to travel an hour to make her request in the physical presence of her doctor.
I had to physically go get myself in front of this doctor, which is hard when you're dying. So I was profoundly malnourished and dehydrated and vomiting pretty much constantly. So it's rough to drive 45 minutes and sit in a waiting room and, have to get dressed and engage with someone who you might puke in front of. By the time I was talking to the actual physician, I'd thought about it for literally years. So, I think removal of that requirement would be just a huge relief.
Second, S.74 would fix a technical error in Act 39, which currently provides explicit legal immunity only for the doctors involved in the process. Pharmacists, in particular, have been reluctant to participate because of this defect. The S.74 amendment would clarify that acting in accordance with the law would itself protect all parties involved from claims of liability. The third provision of S.74 would adjust the steps required to get a prescription. The proposed amendment keeps the mandated 15-day waiting period between the 2 oral requests, but removes an unnecessary and burdensome additional 48-hour delay after the last step in the process before a prescription can be written. Please listen to Dee Allen explain how this provision added to her suffering.
The hardest part was waiting that 2 weeks and then the 48 hours to calling in the prescription. For crying out loud, why? We've already decided this is what it is. We've been working on this together as a team for weeks. As far as the 48 hours, I have no idea why that is in there. My primary care, Matt, doesn't know. He said, I don't want to wait, but I have to. And he said, and because of the day of the week it was going into a weekend, so he knew he couldn't call it in until the following Monday, so that actually made it 3 days instead of 2. It's a time that can make it so that you don't have access to the law. I'm timing this very closely. I just have to make it to Monday.
Thank you very much for your interest. Medical aid in dying is an important and powerful option in the spectrum of compassionate care toward the end of life. S.74 would remove needless suffering for people who choose this option.